All right, and hello again. Welcome back. Attorney Steve Vondran here. We are talking in this video about the top 25 ways to break, cancel, or terminate a contract or a lease. Okay, so essentially a contract and a lease are the same thing, but we'll talk about it in a second here. Attorney Steve Vondran here. And our disclaimer, as usual, this is not legal advice or a substitute for legal advice. This is not a complete and accurate list of all the things you may find in the area of breaking contracts. We are licensed practice law in California and Arizona. We do handle breach of contract cases and also federal copyright and trademark cases nationwide. All right, so first important question to know if you're talking about how do I get out of a contract is what is a contract? Well, essentially, as my law professor taught me, is that a contract is a promise or a set of promises that the law will enforce. There's a very simple definition of it, but a promise or a set of promises the law will enforce. Basically, it's you contracting with someone else. There are thousands of different kinds of contracts. When you go in and you buy something at the store, essentially they're offering to sell you a television and you're buying it for $500. So there's lots of different kinds of contracts. Leases are also synonymous with that. A lease would be like for an apartment or condominium or whatever. You're leasing a mobile home or whatever the case may be. But so a lease and a contract are essentially promises or sets of promises the laws will enforce. Each contract, most contracts have unique terms and conditions, and we'll talk about that in a second. So a contract is basically usually a piece of paper that two parties put an agreement on. Could be a napkin. It could be an oral contract. It means that you stated it verbally. So there's lots of different kinds of ways, lots of different types of contracts. So let's talk about the 25 common grounds to get out of a contract. Step one, the first thing you're going to want to do if you're facing a situation where you're trying to get out of your contract is to give it a thorough read. Pull it out, dust it off, do what you got to do, but take a look at it. What are the terms? Oftentimes parties get into their contracts and they feel they have a strong case and they want to file a lawsuit and they don't even know that there's an arbitration clause in there. So take it out, give it a read. What were the parties required to do? What were you required to do? What were they required to do? Who breached the contract? Take a good look at that. And step two, as we have here, explore the potential grounds to nullify, void, rescind, cancel, etc., etc. In other words, watch this video to the end. And actually, I don't know if you knew that or not, but if you watch my videos to the end, it helps improve my search engine placement because you're watching more of the movie. So don't be afraid to watch this all the way through, folks. All right, let's get down to it here. Number one, first ground, these are some things that I'm going to be looking at as an attorney. If somebody came to me and said, well, I want to break my contract, I'm just tired of it, I got to get out, or it's killing me, I'm not making money, or I'm quitting, or all the different reasons that people want to basically break a contract. But first thing I would look at is this the type of contract that needs to be in writing to be enforceable? So number one is contract not in writing. Now, this is what we call the statute of frauds. A statute of frauds is essentially, I guess it's a statute. It's to explain to people that you're doing something significant, and so you need to put it in writing. If it's not in writing, certain types of contracts will not be enforceable. The one that comes to example really quick is real estate. You know, you never buy real estate without signing a bunch of documents. So if you think about it, those real estate purchases of land, those kinds of things need to be in writing. If they're not in writing, you know, an oral contract to buy 10 acres of land most likely will not be enforceable. You may have rules that differ in your jurisdiction, but you know, something to think about. Co-signing for debts of another. So this is where you go to buy a car and your parents co-sign for you. Again, you'll note that your parents are co-signing in writing. If these kinds of things, and there may be others depending on your jurisdiction, if these kinds of things are not done, if it's not reduced to a writing, again, here's what you argue. Judge, there's no writing, contract not enforceable. Okay, so that's ground number one. If you're still with me, we've got a chance to get to the end here. All right, number two, fraud in the inducement. Now, this is something, again, these defenses could pop up even in a small claims case, for example, if you're in a small claims court. And in California, one of the jurisdictions where I practice, the small claims court goes up to $10,000. So it's quite a bit of money. And so knowing these defenses and grounds to cancel and rescind, these are very important to know, aside from just being general good knowledge to have. So this is number two, fraud in the inducement, false representations of fact intended to defraud a plaintiff. Now, I just paraphrase that to make it short and sweet. It's not exactly the legal definition, but it's close. It's essentially false representations that are intended to induce a plaintiff to do something, and when I say plaintiff, that would be the party that would consider filing the lawsuit. So false representations of fact intended to defraud. An example, rolling back the odometer. This is the classic example. You go to the car dealership, the salesman comes out, Slick Willie, and he's ready to tell you all these great things, and he says the car's only got 10,000 miles on it. It's a 1995, but it's only got 10,000 miles on it. So you believe the odometer, which is a representation of fact of how many miles the car has on it, and you go ahead and buy the car, only to find out later that the car actually had 100,000 miles on it. So somebody was giving you some fraud and, going beyond what we call sales puffing. Sales puffing is, this is the greatest car in the world, folks. You're going to love this. It's going to take you across the country. That's sales puffing, 1 gallon a tank. So sales puffing is generally acceptable, but when you cross the line and you're making these false representations of material fact, things that are important, the reason you buy that car and the price that you were paying is because there was a representation about how many miles it was on it, and you made the decision to purchase based on that. So these false representations of fact made with scienter, as we call it, the intent to defraud, are things that you may be able to use as grounds to cancel or get out of a contract, okay? And so this is why we always say, by the way, one of the things as a lawyer we're always telling people, contracts are made to be broken. I write a lot of contracts. Contracts can be difficult to write because it's hard to anticipate everything that's going to happen. But fraud in the inducement, put that in your toolbox in at number two. Let's go to number three, top 25 ways to break a contract. Unconscionable contracts. What is that? Well, probably as it sounds, wow, that's unconscionable. This is what we refer to as one-sided contracts. They can be overly weighted in favor of one over the other. It could be what we call a take it or leave it contract, which is like an adhesion contract. Now, this would be when you go to the car dealership and you're signing paperwork. That's not really negotiable. That's not negotiable. So you go in, you sit there, they tell you all the terms. They even give you the time to read it, as if you have, you already waited 4 hours to get into the finance booth. Now you're supposed to take another 4 hours to read the contract. That's not even negotiable to begin with. This is what we refer to as a take it or leave it contract. They're usually not negotiable. What's also referred to as adhesion contracts. Now, a lot of times adhesion contracts will be enforced. It's not to say or suggest that these are non-enforceable, but if you have really coercive and unfair terms to the contract, if it reaches the level of what we call shock the conscience of the court, if you get to that level where you go, wow, that is just so unfair, it's so unconscionable that we are just not going to enforce that. As noted here, courts may decline to enforce that agreement. So that may be one ground to get out of your contract. It's unconscionable. It's unconscionable, okay? That's number three. Let's go to number four. This is more of a contract formation issue. This is the contract lacks consideration. Now, in order to be enforceable, contracts must have what we refer to as consideration. Now, you may say, well, what's consideration? Well, consideration is what we call, something you're giving for the deal. It may be $500 for the TV set. You may be giving up the TV set in exchange for the $500. This is what we call legal bargain for detriment or exchange. There has to be an exchange of value. So each side has to be agreeing to do something or refraining from doing something. This is key. This is a key for you on the bar exam. We have some people that like the bar exam stuff, or refrain from doing something is legal detriment. Saying, well, I refrain from going, from taking this job. So there's legal detriment there. So there has to be some kind of consideration in a contract if you want it to be enforceable. So I have an example here. One is if your parents promise $500 if you get straight A's, then you are forced to do something. You're forced to start whipping it into shape and getting the better grades and putting in more time and studying harder. So you're doing something and you're refraining from doing something. You're doing both. So under that scenario, if you get straight A's, you would say, well, you need to pay me $500. And so, now the other promise I have, this is what we call the gift promises, or the promises that really, they're just, it doesn't require you to do anything. For example, I will pay you $500 if you grow over 6 feet tall. That may not be enforceable because you're not doing anything. You're not really agreeing to do something or refraining from doing something. There has to be some level, ascertainable level, of what we call bargain for legal exchange. Okay, so if it doesn't have that, if your contract is, hey, wait a second, I'm the only person giving here, you may have an issue of a failure of consideration, or what we also refer to as want of consideration. Okay, and under these circumstances, you would argue lack of consideration voids the contract, makes it unenforceable, so forth and so on. That's number 4. Number 5, termination clauses. Remember at the beginning of this video, I said to look at your contract, read it closely, read it thoroughly. Look and see if there's any termination clauses that may allow you to get out of your contract. Like a cell phone agreement, you may sign up with a service provider and you're agreeing to pay something, but the contract gives you the right to cancel by notifying them with 30 days advance notice to a certain address. Okay, so you may have ways to break your contract that are right there in the contract. All you have to do is read it and follow it. And so that's number 5, termination clauses. Okay. Number 6, you may seek to cancel a contract when the other party materially breaches the contract. So this is an interesting one. So when we're looking at contract issues, and we're looking at contract issues, and one party is trying to assert a breach of contract against the other, usually the question is, well, did they commit a material breach? Material breaches, if somebody says, for example, I'm going to pay you $200 if you come and mow my lawn, if the person doesn't show up and mow the lawn, they have materially breached the agreement. So under that scenario, your performance may be excused, meaning you don't have to pay the $200. So that's important to know. And so every time we're looking at a breach of contract situation, we're asking who breached. Did the plaintiff breach? Did the defendant breach? Did they both breach? Who breached first? Those are the kinds of questions we're looking at. Another important issue is the breach of the covenant of good faith and fair dealing. If you've never heard this, basically what this is saying is in every contract that you enter into, your mortgage payments, your lease payments, there's a covenant of good faith and fair dealing, which is implied in the contract. So that means both you and the other party need to perform your obligations in good faith and with fair dealing. And a breach of that could be considered a breach of contract. And again, the question becomes whether or not it's a material breach. If it's a minor breach, if it's only considered a minor breach, if you stop your performance believing that it's a material breach, but it's only a minor breach, you could be deemed the breaching party. All right, you following all that logic there? So it's always important to know what was the material breach. If the other party material breaches, maybe you can get out of your contract. But again, this is tricky. Probably best to get legal advice from a contract lawyer. Yeah, that means call us if you are being sued, okay? All right, number 7 on the top 25, impossibility of performance. What is this? Okay, so it's, as it suggests, unforeseeable events make it impossible for me to perform the terms of the contract. So because I cannot physically perform the agreed terms. In other words, say I come out, I'm a band, and I say I'm going to come out and perform in the stadium in downtown San Francisco. I say, well, the stadium burns down, or let's say there's an unforeseeable tornado that tears down the stadium, maybe in Florida, let's say, and I had contracted to perform at the stadium, but it's not there anymore. It was blown to the ground. Well, it's impossible for me to go out there and fill the stage with fans and perform my music. So under those circumstances, it would be impossible to perform, and thus you would argue cancellation of the agreement should be able to be sought and obtained. Okay, so that's number 7, impossibility of performance. Number 8, rescission rights. Okay, this is important to know. Now, rescission really means cancel. I mean, basically means to rescind or cancel your contract. Now, there are some statutes, and I'm going to give you 2 that I'm aware of that I have dealt with in various circumstances, just to give you an idea of what I'm talking about here. Okay, so example, we have a truth in lending law. So let's go back to the car contract. When you go in and you obtain financing, has the APR, the annual percentage rate, how much the finance charge is going to be, so forth and so on. There are some required things that need to be in that disclosure. If there are material violations of TILA, the Truth in Lending Act, and let's just say we're talking about a real estate refinance, okay? As it says here, a non-purchase loan. I don't want to get too technical on you, but under the Truth in Lending law, if the lender is making material violations of the Truth in Lending Act, and let's say you're refinancing a condo, you may have rights to rescind that contract and cancel the agreement. And there may be, again, some steps you need to follow. I can assure you there probably is. There is, I should say. So that is one example. Now, I have another example. This is California Civil Code Section 1632. Write this one down, look it up. This is a fun one. Now, this is the situation where you have certain, let's say a company, a refinance. I do a lot of real estate law, as you can tell. But so say you have a company that's trying to get people to refinance, and they're targeting people in a certain area, and they're saying, well, we're going after the Hispanic dollar, we're going to refinance all their loans, and this is a zip code that is, we think is good. And so say they're targeting it with, Spanish telemarketers, let's say, and they're negotiating and discussing the deal in Spanish. There could be a requirement under California Civil Code Section 1632 that this is one of those contracts that are required to be in the language of the party that was targeted and solicited. So it's an interesting law. So under those circumstances, if your contract was not in that language, you may have rights to seek to cancel that agreement. Okay, does that make sense? That's number 8. If you're still with me, hang in there. It's going to get better, I swear. I'm warming up. Number 9 on our list, top 25, no definite and certain terms, vagueness, ambiguities, vague and ambiguous, so forth. Now, here's the main point here. Courts must be able to understand and enforce the terms of the contract. So, you can't hand a judge a piece of paper with 2 sentences on it and say, well, here, this is, we were going to do this and that and this and that and this is what the contract meant. That he was supposed to do this and I was going to do that and he was going to do that. And the parties go back and forth and back and forth. The courts must be able to understand the terms of the contract. And usually what we're looking at is, the 4 corners of the document, looking at what does it say? What is the intent of the parties? What does the plain language of the contract say? So if you can't understand it, it's vague, ambiguous, it's uncertain, it's unintelligible. If the material terms are hard to ascertain, then you may be able to argue that the contract is not enforceable therefore allowing you to cancel because there are definite and uncertain terms, okay? So that's something to consider, and usually you'll know that, or you'll read the contract and you'll go, I don't really know what this means. And so that's the point where you may want to seek legal advice and see if you have grounds to cancel with, a certain degree of safety to canceling. So that's number 9. Moving on to number 10, minor contracts. Okay, this is contracts entered into by persons under the age of 18. These may be voidable at the discretion of the minor. Again, check your state, local rules. Possible exception is if the contract was for necessary services. So let's say a 17-year-old, goes out and buys a jacuzzi. The jacuzzi may be something that's fun and nice to have, but not something necessary. So say it's a $3,000 jacuzzi. That contract might be able to be avoided by the minor, basically saying, well, I was under the legal age and I entered into this contract and, my parents told me I was an idiot. So, I need to cancel. So that may be another ground to cancel. And again, as it notes here, if let's say it was for you were buying, textbooks, something like that, food, clothing, those kinds of contracts may be deemed necessary items, and you may not be able to void those. Okay, so that's something to think about. Minor contracts, check the state, the age of minor infancy in your jurisdiction, and take it from there. So that's number 10. Let's go on to number 11, constructive eviction. Okay, this is for you people that are leasing apartments, houses, timeshares, vacation rentals, whatever the case may be. There is in a lease, you have usually the person who's leasing the property has the right to the quiet use and enjoyment of the property. So if something's happening, and I have some examples here: failure to maintain the common areas, inadequate safety measures, excessive roaches, rats, bed bugs, leaky plumbing, lack of hot water, slum landlord, as it says here, then you may be constructively evicted, and that may give you grounds to cancel your lease. Again, check your statute. You may have to give notice. You may have to give notice under the law in your jurisdiction. So this is something in California that we refer to as a constructive eviction, and that could give you grounds to cancel a contract or lease. Okay, that's number 11 on our hit list. Number 12, duress. Okay, wait a second. So I entered this contract, but there was a lot of pressure on me. There was force or fear, unwarranted pressure tactics, threats. You do not have to be a fiduciary. A fiduciary is really a person in position of trust. And the defendant, as I said, let's say you're the one that ends up getting sued, should be prepared to argue that he or she would not have entered the agreement but for the distress. Okay, an example for this that I've seen come up is people enter into these foreclosure rescue services agreements. We'll help you get a loan modification for your house, and people are all stressed out because they have foreclosure coming. Now, that's kind of their own cause duress, their inability to make their payment. But, what happens and what people sometimes argue is, well, I was under duress and I would not have, they came to me at the last minute and he tried to buy my house for $200,000. I didn't know what else to do and I freaked out. So, in cases where there is unwarranted duress, you may be able to get out and cancel that agreement. Okay. Number 13, filing for bankruptcy protection. If you file bankruptcy, now there's chapter 11, 7, 13. Probably others. There's an 11, I know that. So, but if you file bankruptcy protection to avoid fulfilling contractual obligations, example, to avoid paying a cell phone bill, cable bill, so forth, or paying your mortgage or your lease, this may operate, as we call it, to stay and or to eventually discharge your obligation to pay. As we note here, it's always best to discuss bankruptcy with a bankruptcy specialist. For you people in California, you can go to the California State Bar. They do have a specialist search. And when it comes to the area of bankruptcy, that's one area where I really like to have a person that knows what they're doing. They do this day in and day out. And I also feel the same way about tax lawyers. Okay, so, and for that matter, all lawyers. Okay, so at any rate, filing bankruptcy could allow you to eventually cancel your deal. And you can also renegotiate deals in bankruptcy, by the way. All right, number 14, top 23 ways, top 25 ways, I should say, to cancel a contract. Mutual mistake of fact. What's this? Here you have two parties that are mistaken. So you have what we call the offeror and the offeree. These are the two people that got into the deal, into the contract. However, let's say, and I think the case from law school, I'll give you what I remember was what we call the barren cow case. And this was a cow that the guy thought he was selling a cow that didn't have babies, that was, a non-pregnated cow, and it came at a certain price. Well, then when they found out, both parties believed the same thing to be true, that the cow could not bear calves, I guess it is. But so they both were under the impression or belief that the cow could not bear, and then lo and behold, old Bessie was able to have kids, and the value of the cow went up, so forth and so on. And in that case, the seller wanted to back out. He said, well, I should have got a lot more than this. We didn't know that the cow could bear calves. So, there was a mutual mistake of fact that they would argue allows them to cancel the contract. Does that make sense? So mutual mistake of fact, both parties are under a false impression or belief. And as I note here, mutual assent, the key words, a mutual mistake of fact prevents the parties from having what we call a meeting of the minds and the mutual assent needed to form a contract. So this is technical contract language here, but for you that are following that, good for you. Okay, that's number 14. Number 15, accord and satisfaction. This one should be called negotiation. Now, and I point it out here because I think some people don't think about it as, lots of things in life are negotiable. So, if you need to get out of your contract, sometimes you call the company and you say, hey, I need to get out of my contract. What are you guys going to do? Do you guys have something you can do for me? Do you have a procedure for that? Or is there a form I fill out or a fee I pay? Or how does it work? But you can seek to negotiate a better deal, taking into account changing circumstances, changing realities of life, so forth. And sometimes deals don't work out and you have a contract with a vendor and it doesn't work out and you say, well, I still need my supply, but I need to renegotiate the deal. So accord and satisfaction is a way for parties to get together, talk about it, reach an accord, and basically satisfy the old contract and basically enter into a new contract. What we say here, cancel the old contract by superseding it with a new or amended contract. So negotiation. So if you don't like your deal, you're thinking of canceling, see if you can get an accord and a satisfaction. Another related concept is the novation, and that's where you bring in another party to be responsible. Everybody agrees. Okay, so that's another thing that you can consider. Number 15. Number 16, contract violates existing law. So you may say, well, wait a second here. This banker over here is trying to enforce this loan agreement and they're charging 30% interest. That's like crazy. I only did it because I was desperate, but that may violate the usury laws, which relates to how much insurance you can charge, or how much interest rate percentage that you can charge. So, lots of states have laws on what the max is. So you may have a contract that essentially is illegal. It violates another statute. It violates existing law. Things like that. You may argue to the court, this contract is void, unenforceable. It's illegal. It's against public policy. So you can see how you weave some of these together when you're making your arguments and your pleadings. Some of these are, as you can see, overlap a little bit. So you want to just get that little flavor in there of what's going wrong. Okay, so that's number 16. Moving on, 17, undue influence. Okay, this is where you have the person with a position of trust. Remember I talked earlier about fiduciary? This is where we're talking about that person with position of trust. And they take advantage of the person. They overcome their will. And, persons in positions of trust is like a trustee of a trust, an attorney, maybe a doctor and the patient, where you have positions of trust, caretakers, things like that. Now, if you have somebody in these things, and my example here is an attorney who contracts with an elderly client to have the attorney buy their property, let's just say, $200,000 below market value. The elderly client trusts the attorney, trusts that they're going to be making fair deals, and trusts that everything's going to be on the up and up. If it's not, and it's a bad deal, you could see an argument like this coming in saying, I don't want to be held to that deal because of undue influence, and therefore the contract is unenforceable, Your Honor. So that may be an argument for you if you're looking to cancel on grounds of breach of a position of trust. Okay, that's number 17. Moving on to 18, illegal subject matter. This is easy. The subject matter of the contract deals with illegal subject matter. This could be gambling, beating someone up at a Trump rally. This could be prostitution. This could be anything that's illegal that you're making a contract for. In other words, an offer, an acceptance. You have the consideration and you have a contract, okay? So if that deals with something illegal, then you may have a person that's able to cancel that without any repercussion. Number 19, commercial impracticability. Commercial impracticability, say that 5 times fast, and you get your honorary degree here with Attorney Steve University. I'm just kidding. Don't send me everything in. So commercial impracticability, we have unforeseeable events. Again, unforeseeable, could not have been foreseen or anticipated. You couldn't find a way to guard against the risk. It was an unforeseeable event, which makes the defendant's performance of the contractual obligations commercially, meaning economically unfeasible or unreasonable. Okay, so this is where, let's say you get into a deal to excavate a certain amount of land and you think it's all dirt, and then you start excavating and you see, wait a second, there's cement down here and it's going to cost, they paid me $50,000 to excavate the dirt. Now that we found cement, this is going to be a $2 million job. So under certain limited circumstances, in unforeseeable events, those kinds of things, you can argue commercial impracticability, argue the contract should not be enforced. Okay, does that help? Let's move on to number 20. I like this one. This is the frustration of purpose. I love it just because of the name of that. Frustration of purpose, Your Honor. Again, here we go. We're using that same word. Unforeseeable events that frustrates the purpose of entering into the contract. So here, let me give you the example from law school. Now, this is what I call the King's Coronation case. And by the way, for any of you bar exam buffs out there, I may have my facts a little jumbled. That was a long time ago. But I'm going to tell you just kind of what I remember. So this was the King's Coronation case. And I forget exactly the details, but a guy wanted to see the king's coronation, and he bought a ticket to the coronation. So he paid money to get the ticket. That's our consideration, offer and acceptance. So we have our contract there. We have the legal exchange of value, as you see. And then what happened, and I forget what it was, for some reason the king had to cancel, could not make it, so forth and so on. So now he had this ticket, you had this thing, but it was worthless. And so the guy eventually ended up arguing, and I couldn't even tell you if he won. I believe he did win. This was a case coming back, I believe, from England, but this was frustration of purpose was the argument. Your Honor, this agreement for the ticket and the concert or the coronation is worthless to me now. The king's not showing up. So the return performance from the other party has no value to me. Okay, and it was not due to anything that I did. Okay, so that's frustration of purpose. So if you have something that just the deal goes completely sour for some odd reason, you may have some relief. And I say again on all these, I say you may. I don't say that you do. You have to look into it. Everything will depend on its facts. Sometimes it depends on what jurisdictions you're in. But, these are things that you want to be thinking about, okay? Number 21, moving on, 21 out of 25, incompetency or incapacity. Okay, this is easy. This probably makes sense. Again, we talked earlier about the need to have a meeting of the minds when you're trying to have an enforceable agreement. I know what you want, you know what I want. I want my lawn mowed, you want the $200, I want the ticket, you want the $50. We have the meeting of the minds, okay? And that's something you need to have a contract. But where you have incompetency or incapacity, somebody's insane, somebody is drunk, intoxicated, under drugs, under the influence of drugs. I have here elderly person who is senile, does not understand they are entering in a contractual relationship. They don't understand the nature and quality of the acts that they're doing. Again, argue contract is void and unenforceable. Number 21. Okay, moving on. Number 22, contract is invalid, violates a statute, law, rule. This is similar to the previous one that we had, and I just wanted to give you a different example. So we have the antitrust laws. Usually there's state and federal antitrust laws, and so they usually say not to do anti-competitive things that harm the marketplace, so forth and so on. So if you have a contract, and like, for example, maybe a non-compete agreement, where it says, I can work for you for 2 years, I get paid, but after I'm done working for you, I can't work in the same field anymore. So, you have these non-compete agreements which, may violate like the Sherman Antitrust Act, for example. So you have these, again, weave it in there. It goes along with the argument of the contract being against public policy, which we'll talk about shortly, or illegality. So again, this is something you want to say, if it's violating other laws, why would I not be allowed to cancel the agreement? It's basically a legal contract. Okay, so I just wanted to give you a different perspective on that. Number 23, almost done, hang in there. Material misrepresentations. Again, this is material. Material under contract law, generally speaking, goes to the heart of the agreement. So it goes to that essence. It's not one of the little terms in the page 24 of the contract, paragraph 3 and 7 font that says you have to send notices to something like that. It goes to the heart of the agreement, what you were really bargaining for, what you really wanted. Okay, so if you have a material misrepresentation, now this one doesn't have to be intentional with scienter to defraud. This is just something where you made a material misrepresentation. You said there was 20,000 miles on the car, and in reality there was 50,000. And so the representations were false. So this is another area where you may see people trying to get out of a contract because of material misrepresentations. Very similar to fraud, slightly different. Number 24, statute of limitations. Anytime you're trying to get out of an obligation, you're looking at the statute of limitations. If enough time has passed from the date of a breach, you might be able to cancel the contract without fear of being successfully sued. So, for example, in California where I practice, you have a breach of a written contract, you have 4 years to file suit. So if you have been in the contract and it's been 4 years since you breached the contract and nobody's done anything, you may feel safe in canceling and just ignoring the obligation. I'm not saying to do that. However, I'm just saying it is maybe potentially a legal option for you. So that's number 24, statute of limitations. That's going to vary by your state. You need to check with your local state attorneys on that and see what's going on, okay? Number 25, and finally, this is what I call the catch-all. This is contracts against public policy. So if you have some obligation to do something, or a deal was made that's grossly unfair, so forth and so on, you may be able to argue that something is against public policy. It's not good public policy, Your Honor. People shouldn't be allowed to do this. I mean, this is not good law. This is not a good society that allows contracts like this. Here's one that I had here, an example. Selling an old lady dance lessons for $25,000. And she just didn't know any better, and next thing you know, you're getting $25,000, aside from potential financial elder abuse there, which is also a viable cause of action in California. there's something inherently wrong with that. Is like $25,000, that's a lot of money. I mean, why technically, I guess people can pay whatever they want to pay for something, but that's an awful lot of money. So there may be situations that you argue this contract is against public policy. Again, it's based on the notion that legal systems should seek to uphold standards of morals, fairness, and decency. I made that up, but that's what I believe. Okay, that's it. We're done, folks. We have got to all 25. I hope that's been some great information. I hope you've given it some thought and, think about your situation. If you need help, give us a call. There's our number. If you need to know more about affirmative defenses in general, these are defenses if you're being sued. I have my website there, raiseyourdefenses.com. It's a pretty popular page on my site, raiseyourdefenses.com. That's about it. If you like this, subscribe for more great legal videos. Not a lot of attorneys out there trying to help educate you and help you be smarter than your friends. Attorney Steve is looking out for you for sure, okay? Thank you for watching. Share the video if you like. There's our disclaimer. Everybody, have a great day, and thank you for your continued support. That is the top 25 ways to try to cancel, break a lease, or a contract. We'll talk again.